Welcome back. Now, businesses are increasingly embracing alternative dispute resolution in solving tax disputes with the Kenya Revenue Authority. To save on time and costs, Kenya introduced the provision for alternative dispute resolution in 2015 under the Tax Procedures Act. I had a sit-down with Risper Simiyu. She is the head of tax dispute resolution at the Kenya Revenue Authority to take stock of the option 5 years since its introduction and what businesses need to know. This is how the conversation went. Know that you can solve tax disputes outside court. This is under the alternative dispute resolution mechanism at the Kenya Revenue Authority. And to just give us an overview of what that means, how this can be done, and what it has achieved so far is Risper Simiyu. She is the head of alternative dispute resolution at the Kenya Revenue Authority. Welcome on set.
Thank you very much.
Could you just introduce us to what alternative dispute resolution is?
Okay, so alternative dispute resolution, simply put, is a mode of resolving disputes outside the quasi or judicial processes. So basically, we're addressing disputes outside the tribunal or outside the court process, simply put.
And how can maybe someone who has a tax dispute get in touch and get this process going?
So what we have done, even on our website and through various stakeholder engagements that we have had, is to introduce our taxpayers, in this case our clients, or the commissioner, in this case, who is the assessing party to this process. Mm-hmm. All you need to do is send a form. There's a form on the website. You download it, print it, sign it, fill it in, and then scan it through to us under this COVID times. Mm-hmm. So you scan it through and it simply explains, you put in your details, the name, dispute at hand, and the reasons why, and even the value of the dispute. And that, in essence, then kickstarts the process of the dispute resolution.
Even before you get to that point of filling that form, how do you know that you qualify for this tax dispute resolution mechanism?
So the dispute resolution process under ADR has certain steps. So the first thing, as a taxpayer or a commissioner in this case, who is either party, can apply. So you send in an application to us. That, in essence, then indicates your intention to resolve the disputes through the dispute through the ADR mechanism. Now, once we receive that application, we take it through a process called a suitability test. Internally, we call it the case review forum. Mm-hmm. Now, that forum then analyzes your dispute to determine whether then it's fit for purpose as far as the process is concerned. Mm-hmm. After that, we then communicate to you the outcome of the suitability test to see whether your case is fit for purpose or not. Now, assuming that is in the affirmative, then we call the parties for meetings. And when we say parties, it means the assessing commissioner and the taxpayer. Mm-hmm. Now, the process will go on through various meetings, sometimes working meetings between the two parties, and that then culminates into an agreement, what we call the ADR agreement. After the agreement is entered into by the parties, then it then moves into a consent. A consent is drawn, and if the matter was at the tribunal, the consent is filed with the tribunal, or it is filed with court. So it depends on where the matter came from.
This suitability criteria that the case has to go through, as you said, could you just take people or Kenyans through what that takes so that they are sure that this tax dispute I have with KRA will pass the process?
Okay. Our position is that all disputes, all tax and customs disputes are fit for purpose as far as ADR is concerned. But we have certain exceptions. So if settlement of your dispute will be contrary to provisions of the Constitution or revenue laws or other enabling laws, then that is a case that we would not touch. Mm-hmm. If it is a case that borders on interpretation, now, it is important I qualify this because sometimes you'll find that wherever, much as we have disputes between us, so in this case KRA and the taxpayers, we all read from the same revenue acts, but then we have different interpretation.
Right.
So when we receive the submissions from, say, the taxpayer or the commissioner, we are able to determine, is it an issue of misunderstanding on the part of one party, or is it an issue of interpretation that then would rather be done by the tribunal or courtroom? Mm-hmm. Now, if it is again in the public interest, that a matter be pronounced, say by a tribunal, pronounced upon by the tribunal or court. So if it's a matter affecting a certain industry and you do not want to apply, inconsistent ways of resolving the dispute, then we'd rather that the matter proceeds to the tribunal or court. Now, if any party opts not to engage in ADR, that for us is key, because as it is, in ADR we engage in facilitated mediation. Facilitated mediation counts on both parties consenting to the process. So even if a taxpayer applies for that process and we engage the commissioner, and commissioner says, no, I am not willing, or vice versa, the commissioner applies for ADR, the assessing commissioner in this case, and the taxpayer says, I'm not willing, then beyond that we cannot proceed. Now, one other item that I wish to mention at this point is if the matter has criminal elements like fraud, whereas I do appreciate it's not for us to determine that this is a fraudulent matter, what we have done is try to qualify that and say, even if there are issues to do with tax evasion, for example, if we've determined that there's an issue of tax evasion, we may, subject to the agreement of both parties, try to do away with that, so park that element, but then focus on the technical aspects of the case. Yeah, so the focus on the tax issues and then park the others, which then will be subjected to a different process.
So if someone has a tax case maybe going on right now in court, is this option open to them?
This is a process that started in 2015. And what happened is, and I like to say this and really in jest, that KRA perhaps has been known, rightly or wrongly, over time as a big brother with a stick. And it's something I use all the time. Because you see, when people hear KRA, freeze, you panic. But KRA has made a deliberate effort to move from enforcement to trust and facilitation. So out there, we're actually calling upon our taxpayers to come in and trust, try the process. We know most people, especially the taxpayers, were a bit jittery when we started off, because, there's that fear of, okay, fine, these are mediators, but they're internal. So how sure are we that the process will be objective and fair? But I must say that going by the numbers and the statistics over time, it has been on an upward, and I mean upward trajectory.
Do you have those numbers?
Oh, yes, I do. Let's maybe go back to probably 3 years ago, yeah? Like I said, it started in 2015, but probably going back to the year 2017-2018. In the year 2017-2018, we resolved 90 disputes, full year, and those 90 disputes then unlocked revenue worth 3 billion. In the subsequent year, 2019-2020, there was a major leap. So in that year, 2019-2020, we resolved quite a number, 237. So a leap from 90 to 237. And those 237 disputes unlocked 8.1 billion Kenya shillings. In the year just ended, June 2020, there was another leap from 237, probably not as big as the earlier one, but I think as the taxpayers continue to gain confidence, we are seeing these positive statistics. So that moved from 237 to 284. The 284 unlocked revenue worth 9.5 billion. So they are big numbers. This year we are hoping to do nothing less than 270 cases, and we are also hoping to unlock revenue not less than 10 billion. And those are just numbers that we have tentatively, and we know these numbers will continue to grow.
Well, you've mentioned those numbers for this year, and I'm worried. Has the coronavirus affected these meetings?
When the COVID-19 scare came and the reality of it, it is important to know that even with the corona, these disputes don't go away. Right. The pain for both the taxpayers and the commissioner does not go away. So what we did was quickly move our meetings, which were previously physical, to virtual. And where the taxpayers were willing to engage, when the commissioner was willing to engage, we continued. Exchange of information doesn't have to be physical. The parties don't have to come to a meeting. So that has continued virtually. And so far, we've seen, like I said, we just closed 284 cases. And the bulk of them were between March and actually April and June. Impressive. So we are happy.
So you think this movement to maybe some virtual operations might even hasten the processes?
It should. We've received very positive results. If you realize, before that time, ADR, and it's important that I state this, as it is now and based on the numbers that we have now, ADR is located, the ADR team is located in Nairobi. So what have we done to ease the burden for our taxpayers is that if parties had a dispute, say, in Nakuru, in Kisumu, in Eldoret, in Mombasa, all those regions, once we have a number that makes commercial sense to make the move, then I put together a team, and in this case maybe a facilitator and someone to support the facilitator and take them to that region.
All right.
So we come to the people, as opposed to getting that person on a vehicle on the road to come. And you see, if you're talking about 8 to 10 cases, it means you're having 10 taxpayers, plus their agents, plus their lawyers, a whole group of people coming to you. So what we've done is when we have those numbers, we go towards the taxpayer. And in this case, if it's a matter in Nakuru, it means the assessing commissioner is in Nakuru.
Right.
So why have the taxpayer and the assessing commissioner both come here? It makes commercial sense to go to them, because in this case you'll find it's only 2 people, 3 people at most going to them, as opposed to upward of 20 or so people coming to us.
Right.
So that is what we've done. We did that pre the COVID-19 era, but now everything is virtual. So at the comfort of your house, comfort of your office, it doesn't matter. You can log in, dial in anytime and participate in the meeting. Very efficient.
This particular mechanism, the alternative dispute resolution, it has been pitted to hasten the process of resolving these disputes outside the court because of just how tedious and long court processes can be. So what are you doing to ensure that these numbers keep growing and even maybe reach a point where people need not run away from the KRA?
So what we are doing, we are consistently engaging in stakeholder engagement. Consistently. As it is now, and being that now we're on KBC, this is a far-reaching station. Right. It goes far and wide. This in itself, for me, I would look at it as a stakeholder engagement, because I do hope that the message will reach as many people as possible. So, like I said, we engage in various stakeholder engagements. Anybody who can pass a message, we rely on those who have gone through the process to be our ambassadors. Because if someone has gone through the process, whereas someone else would be worried that, are you sure KRA will give me a fair hearing? If someone has gone through the process and come up the other side smiling, which is what has happened largely for ADR, then we rely on that person to pass on the message. And while at it, we keep encouraging our taxpayers, specifically in this case, to engage in ADR because of the various positive aspects that it brings with it. One, it saves a lot of time. You mentioned earlier that it does save time outside the court process or the tribunal process. Now, that process tends to be a bit, even in terms of formality. So let's go back to the issue of time. We live in this country, and we know how long our cases can take in the court process. Now, the Tax Procedures Act, Section 55 to be specific, addresses the issue of timelines for the ADR process. And in this case, it mentions 90 days. So, again, in line with that, we read that together with the Tax Appeals Tribunals Act, Section 28, that sort of mandates the tribunal to grant the taxpayer or commissioner, whoever applies for that process, leave, meaning permission, to allow them to engage in ADR. Now, the 90 days, immediately you're allowed to engage in ADR, time begins to count, and it counts to 90 days.
Right.
So the expectation is that within 90 days, you have resolved your matter. We do appreciate that there are times where, outside factors, external factors, extenuating factors may not allow you to, manage within that time.
Right.
What we've encouraged is when there's a mention coming up at the tribunal, go back to the tribunal, explain yourself, and ask for more time, stating reasons why you could not conclude the matter in 90 days. And that has happened many times, and the process continues to be seamless. So apart from the time-saving aspect, there is a cost-saving element. Yeah? So the cost saving for us is big, and that is one big message that needs to go out there. ADR in KRA is absolutely free. Okay. Now, whereas if you look at the tribunal, the basic payment at the tribunal, you need to pay a fee of 20,000 for your application to be admitted or accepted at TAT. Mm-hmm. For ADR, especially for our taxpayers, we keep telling them they dictate the cost. What do I mean by that? If you want to come on your own, if you want to come with your battery of lawyers, if you want to come with your group of tax agents, it's up to you. So it's a taxpayer who dictates the cost. Mm-hmm. But what you do when you come, it is absolutely free. No filing fee, no charge. Now, again, in jest, I always say that pre the COVID times, we used to have physical meetings. Right. And in those physical meetings, KRA also can be generous. We would serve you with a few mandazis and sausages. So actually, it's KRA giving you as opposed to you parting with any cost. One very key aspect that this process brings with it is the confidentiality element. Mm-hmm. Now, when you look at the tribunal or the court process, more often than not, it will be in open court. So you're there, whether you have your competitors there, whether you have people you shouldn't listen to certain matters about your business, it's up there, it's open. Right. But with ADR, only the parties who should be in a meeting sit in the meeting. Now, it is important to note at this point that all the transcripts, all the documents used in ADR remain within ADR. What do I mean by that? In the event that, unfortunately, this case does not go down the happy path, and by happy path, I mean parties agreeing to agree. Right. So if parties agree to disagree, for whatever reason, any document that was adduced, any transcripts that were prepared under the ADR process cannot be presented in a tribunal court. So it is that confidential, and we've done our best to ensure that it remains that way.
How often does it happen that that does not happen, that parties do not agree?
It happens, yes. But from what just looking back at the couple of years, even in cases where parties did not agree, for whatever reason, we have seen parties subsequently go back to the TAT or to court, and mostly the TAT, Tax Appeals Tribunal, and request to be given another opportunity. So I would actually say we've had very many reapplications, very many. And that tells you that sometimes when parties come, what parties forget is it's ADR, and specifically mediation. Arbitration, an arbiter who has been picked on by both parties because they have to agree. The person sits, listens to the parties, and then makes a decision.
Based on.
All right? Yeah. That decision is actually what we call an arbitral award. And that arbitral award is final, and it is enforceable in law. So that is the difference. With mediation, you lead the parties, you guide them, so that at the end of the day, no party should come out feeling aggrieved. Right. I do appreciate there would be the pain of, maybe I would have avoided paying this tax, but you see, if it was due, it was due, and payable. Right.
Wow, that is quite interesting. I think it's important to make that difference. So what is the role of each party when it comes now to this process? You mentioned that, say, someone misses their hearing or their meeting, for the alternative dispute resolution meeting, and they have to go back to the tribunal. Does it mean they go concurrently, or how does that work?
No, actually, when you have to go back is when time runs. So our 90 days have expired. Right. So what we do encourage, so that it doesn't look like we are, operating outside the set framework, is that you go back to the tribunal, because the tribunal will give you a mention date. Go back to the tribunal and say, we are still engaging, and the other party who is expected to be present will actually agree that, yes, we are still engaging, and we are requesting for more time. So the tribunal will then give you time. Now, in cases of missing meetings, and it is important that, now that you've mentioned it, I think it's important to engage in that one at this point, is that it is not always that we go down the happy path. All right? So there are times when cases collapse, unfortunately so. Okay. And they would collapse for various reasons. So if a party in either party consistently fails to come for the meetings, because you need both parties to move.
Right.
So if both parties just consistently fail to come, if a party opts out, remember you need these two parties to move.
Right.
So if one is out, it means the other one cannot operate without the others. If a party feels that they are not getting, the due process is not being followed, if they feel that the other side is not being objective, then the party can opt out. If, say, one party is requested for a certain process to be pursued, and an example I like using top of my head is if you're engaged in the manufacturing process, for example, and the commissioner has said, I'm assessing you based on the outcome of this line. And you're saying, no, this line did not produce X, it produced Y. And this is how it happens, and this is my input, and this is my output from that line. Mm-hmm. Now, maybe the commissioner would say, excuse me, can we have a demonstration of how this works? Mm-hmm. I mean, it's a fair and reasonable request. Mm-hmm. But you say no. So if that is what you're relying on to justify that the taxes demanded are not exactly it, how then is the commissioner expected to prove otherwise? Mm-hmm. So those are the various, and there are many more, but those are some of the reasons why a matter can collapse.
You've given us quite some rosy picture of this process. Is there more to be done?
There is more to be done. Mm-hmm. And one is stakeholder engagement to ensure that parties embrace the process. We've had, and this, when I say parties, it means both sides, both the commissioner's side and the taxpayer. Mm-hmm. I think a lot needs to be done to make people understand that, if there is goodwill, then it is not just a thing of saying, I intend to close this dispute. Show it, mean it. Come to the table. Mm-hmm. There's the old adage that says, he who comes to equity comes with clean hands. So you come to equity. You want equity, come with clean hands. Let's not have, underhand cards and then they're produced when the time is right and sort of throws everything in disarray. So for us, from where we sit, I cannot overemphasize the aspect of stakeholder engagement.
As we come to a close of this conversation now, could you just speak to Kenyans on what to expect from you moving forward?
Now, to all fellow Kenyans, so what I would encourage is that when you have a tax dispute, don't sit back, feel aggrieved, and almost confused as to how then do I progress this matter? Yeah? How then do I progress this matter? Feel free to approach us as KRA. Feel free to reach out to the ADR team. Feel free to reach out to engage in this ADR process. Because as you have seen, even with the judiciary, even with the Chief Justice himself, has continued to encourage matters being resolved outside the court process. We are moving away from that, fight. It's no longer fight. It's more of people coming together, speaking the same language, and ending up at a win-win situation. So above all, we are moving from the courtroom to the boardroom. And at the end of it all, we'll all come out happy.
Wow, that is quite the place to end the conversation. Thank you so much, Risper, for speaking with us.
Thank you very much.
Well, I have been speaking with Risper Simiyu. She is the head of Alternative Dispute Resolution at the Kenya Revenue Authority, and she has been giving us an overview of what that process entails. Remember, if you have tax disputes with the taxman, as she has said, you should get in touch with them and possibly settle them out of court. It will be a shorter process, maybe less painful. My name is Betty Kiptum. Do continue watching Business Insight. Have yourself a good night.